Now, gentlemen, at the end of the plaintiff's case and again at the end of the defendant's case, counsel for the defendant moved to dismiss the complaint, and you heard the court make its rulings on those motions. You are not to take from those rulings any indication that the court has any opinion as to the merits of this controversy. It only means that the court has resolved that there are questions of fact to be put in your hands for consideration. You understand also, ladies and gentlemen, that it is the function of the court to state the law that becomes applicable to both of these parties and the responsibilities which they owe to each other, and you are to apply that law to the facts in the case, as you find them to be from the evidence adduced here. You understand also that in the summations made by counsel for plaintiff and counsel for defendant in their statement of the facts, that if your recollection be at variance with theirs, you are to use your own recollection and not theirs, and the same rule is applicable to the court itself. In any statements of fact that if your recollection differs from that of the court, you will use your own recollection of the testimony and not that of the court. Now, what is the claim here, gentlemen, and what is the law that becomes applicable to that claim? This action is predicated on the allegations by the plaintiff that on the first day of July 2008, while the plaintiff in the exercise of due care was proceeding to alight from a northbound car on 6th Avenue, and while about to cross in the easterly avenue of said place, the defendant, its servant, agent, or employee so recklessly, negligently, and carelessly conducted itself toward the plaintiff herein in the conduct, operation, management, or control of one of defendant's trucks, that the plaintiff herein, causing the injuries of which the plaintiff complains, and said truck was caused and permitted to strike and knock down the plaintiff, that solely by reason of the recklessness and negligence of this defendant, this plaintiff was injured, and that this plaintiff in no way contributed to the happenings which she claims were the cause of her injuries. Now, what does that particular statement predicate? It predicates what is called in law an action in negligence. By negligence is meant the failure or the omission to use reasonable and ordinary care in the performance of a duty which one owes to another, and which failure to use care is found to be the proximate cause of the happening of the accident. So that for the essential qualifications to be established are that the accident complained of was due solely to the neglect of this defendant or its agent, servant, or employee acting within the scope of the employment. And secondly, that the plaintiff herself in no way contributed to the happening of the accident. That brings us to an examination of the testimony to find out whether or not this rule upon which plaintiff depends has been violated, in that this defendant, through the operation of its motor vehicle by its servant, the chauffeur, failed to use reasonable care in the management and control of that vehicle, and that the plaintiff herself in no way contributed to the happening of the accident. Because, as a rule of law, the mere happening of an accident should not necessarily result in damages or the award of damages. Damages become applicable only because of the violation of a right. And the violation of a right which is claimed here is that this lady, in the use of the highway where she had a right to be, was injured because of the negligence of this motor truck driver in a place where he had a right to be. So that you see, both of them had a right to be on the highway, which is everybody's right. But there are certain rules and regulations and responsibilities that one owes to the other in the particular set of circumstances that have been shown to you by the evidence that has been presented here. There is a rule of law that street crossings have a certain indicated value from a highway standpoint. In other words, a crossing is a place where pedestrians are supposed to cross, as distinguished from the center of the block, where a different responsibility than that which becomes applicable to a pedestrian using the crosswalks. The driver of a motor vehicle, or any vehicle in fact, is charged with the knowledge of the fact that people are supposed to cross at those crosswalks, and his duty and responsibility is to have his vehicle under such control in the use of reasonable care that anybody crossing at the crosswalk within a reasonable time can cross in safety. However, where one attempts to cross the highway between crosswalks, he or she assumes a greater responsibility, being charged with knowledge of the fact that there is where motor vehicles are supposed to move, and secondly, charged with the responsibility of using the care requisite to that situation. Now, that brings into play, in this case, the question of the ordinance that becomes applicable to a car upon the highway. There is no doubt that the rule of law is to the effect that one getting off at a place where cars ordinarily stop, that is, a stopping place in the corner of the street, would not be charged with knowledge of the fact that another vehicle was coming along. But that does not relieve them of the responsibility of using the faculties of which they are possessed and proceeding with reasonable care to avoid possible danger. In other words, the duty rests upon a pedestrian as well as upon the driver of a vehicle.